Quinn is recording. Perfect. All right. Well, good morning, everyone. My name is Martin Petioni. I'm the Executive Director for the Board of Accountancy, and on behalf of our interim chair of the Oregon Board of Accountancy Laws and Rules Committee, I am calling the Laws and Rules Committee meeting to order. Today is Monday, June 22nd. The time is 11:04 a.m. and I'm calling us to order. This is a hybrid in-person and Zoom meeting that is being recorded and is being held at the offices of OSCPA on 10206 Southwest Laurel Road in Beaverton, Oregon. We have a quorum to start this public meeting, and we may have additional members and guests joining us shortly. Please be sure to mute your mic when you are not talking. When you want to speak, please either raise your hand in the room or on the Zoom screen, or use the virtual raise your hand option. Committee members, board liaisons, and support staff can ask to speak at any time. For members of the public observing, please use the public comment opportunity for any comment you may have, unless specifically called upon. In addition, members of the public are limited to 3 minutes of comment, and the chair reserves the right to terminate comment if the comment does not pertain to the issues the committee is considering. Please do not use the chat room for any discussions. Should any technical issues arise, we will pause the meeting until they are resolved. I will now, on behalf of our chair, take a roll call of members and guests, and I will simply start with the folks in the room and then move on to what I can see on the Zoom screen. So I'll start with my left, Sherry.
G. Hunt, Board Legal Counsel.
Suram, Deputy Director, present.
Ray Johnson, Interim Chair, present.
Okay, and then that concludes who we have in the room. And so I'll move on to the Zoom presence. I'll start on what I see on the top left. Jason?
Chase Robinson, Board Liaison.
Okay, and then top right, Beth, please.
Beth Spencer, committee member. I do just want to note that I was not able to hear Sherry McPherson and then the person at the far other side next to Ray when they spoke.
Same.
You have to push the button for the green light. Sorry.
Yeah, so please repeat Sherry for the record because probably others then didn't hear it as well.
Sherry McPherson, present. Sorry, my apologies.
And Elizabeth?
Elizabeth Almer, Laws and Rules Committee, present.
Heard everybody now. Thank you.
All right. Thank you, Beth, because that also fixes a problem for our recording. Let's see here. Let's move on to Amanda.
Amanda Fells, committee member.
Okay. Hey, Amanda, just a note for you. I don't know if you can fix it on your end, but you came through, but it was very quiet. So I don't know if you have an adjustment on your end, much quieter than others.
Is that better?
Yeah, that's better.
Okay.
Okay. Thanks. Melissa.
Melissa Wall, committee member.
All right. Thank you, Melissa. And Quinn.
Quinn Stoddard, board staff.
Okay. Quinn, did I miss anybody on Zoom? Because I can see 6 people, but I can see 5 people on Zoom plus the video here. Am I missing anyone?
Nope. Looks like you got everybody, Martin.
Okay. Awesome. Well, with that, I think, Mr. Chair, we have conducted the roll call, and I think this is the time when I turn it over to you, Ray, to go and do the next item, which is the approval or edit of the draft public agenda.
Thank you. Appreciate your help, Martin. Good morning, everybody. You have the draft agenda. You probably had it, hopefully, for close to a week. Are there any changes to the agenda? Any thoughts about the agenda you'd like to share? Can I have a motion to adopt the agenda?
So moved.
Sherry? I heard a second.
Second.
Okay, that was Beth, I think.
Amanda.
It was
Second.
Amanda.
I'm sorry.
So Sherry moved and Amanda seconded.
Seconded. Okay, thank you. I'll take a roll call vote. All in favor, Sherry?
Sherry,
So you
Thank
make
you.
sure you say your full name. Sorry.
Sherry McPherson,
Elizabeth?
Palmer,
Amanda?
Amanda Fells, aye.
Melissa?
Melissa Wall, I.
And Beth?
Beth Spencer, I.
And Ray Johnson, aye.
Awesome.
Motion carries. I don't see any members of the public at this stage. Are there any members of the public that would like to make a comment? Hearing none, I'll move on in the agenda to new business. Report from the June 4th board meeting. Martin, I'm going to turn this back to you.
Yeah. So I'll keep this brief, but the June 4 board meeting was, let's just say, pretty packed with respect to policy discussions. With respect to the LRC, there were a couple of items that came out of the board meeting and inform kind of really what we need to do today. One is there were some discussions. There were, in essence, 2 rule-related discussions and a legislative concept-related discussion. And the overall direction from the board was the board's priority for the LRC really is the continued work on the legislative concept, and anything that's rule-related is kind of on the a little bit on essentially the back burner. That said, both of the topics, which I don't really want to get into in the interest of time, both of the topics that the board discussed that were rule related happened to be education connected. And one of them was specifically called out and saying, maybe that's not really a laws and rules committee discussion. That might be much better if we pull together representatives of the higher ed community to kind of discuss how best to move forward. I'm okay with also putting on the public domain that in my own thought process that occurred after the board meeting is really that probably that second topic that was discussed by the board is also very education related. So I will actually go back and most likely ask the chair for permission to have, a very temporary kind of convening of higher education folks helping us with both of those topics at the same time. That will probably be the most efficient thing that would allow us at the LRC level to really focus on the primary purpose, the primary top priority that the board has asked us to focus on, which is the continued discussions on private equity. So that's the super high level. Now I want to switch to what the specific board direction is, and that's the part that's reflected more clearly in your materials on what was actually the ask of the board at that time, right? What the ask of the board is that we had the blessing, and I really mean it when I say that, that is not meant with any hint of sarcasm whatsoever. It's true appreciation that based on outreach that I had started probably 2 months prior to the board meeting, you may recall that we had, but didn't get to, an updated draft written by board counsel of our legislative concept from February that had a February date on it. That came to our April Laws and Rules Committee meeting, but it was not really a subject of discussion in April. It was just in the materials, but we didn't get to it, right? So that same exact draft both came to the June board, and that exact same draft that you had in your April materials was also supplied to our contact in the accounting coalition, which is essentially the name we use for the Big Four consortium. We are in PwC territory, so my contact there is a gentleman named Marcus Rayner at PwC. You've seen him at prior LRC meetings if you've been with us for a longer time. And so he supplied back. So they took that very seriously, and they supplied one of the documents that's in your materials that also went to the June board meeting and essentially provided very detailed feedback around mostly unintended consequences. I don't want to characterize it too much and spin it too much in my way, but I don't think I was the only one who felt that it was very constructive, that it was we get what you're trying to do, but unless you get more specific, certain things could happen here, right? And so the board discussed this on June 4, and really the core theme that came out of that discussion, I would summarize as follows. One is the board was very clear that this is not new territory, that we've had essentially discussions both at the board level and at the Laws and Rules Committee level before that was all about how do we walk that line between not really knowing how APS and PE will evolve and avoiding getting too specific. And essentially, we initially settled very deliberately on what is reflected in that draft, right? Which is, can we avoid as much as possible specificity in statute and just rely a lot on rulemaking authority? That was not a ho-hum thing. That was a very deliberate policy choice, right? But in essence, what's clear from the feedback is that policy choice also has a downside, right? Because it does mean that there are very well-meaning folks that do not have an agenda, that don't necessarily want to undermine what we're trying to do, but say, depending on where you go with this rule writing authority, this could become a problem for us, right? And so the issue, the specific board ask that's in the cover memo that you have in your material is the board felt that it was better to have the LRC take a crack at discussing where do we feel comfortable of the specific issue, literally go through this issue by issue and essentially say, where as a committee do we feel like, in terms of that risk and reward balance, right? Where can we take the risk of becoming more specific and address some of those concerns without getting too far down the road of risking that the board would have to come back to a future legislative session to then clean up that specificity? And where is the sense of the committee that we're getting into arenas where it's so hard to predict which way things are going to go, that we're simply going to have to ask that community to essentially rely on us having a good head on our shoulders and be consultative and do as good of a job as possible in the rulemaking process. And that's essentially the ask for today, is for this committee with Ray in the lead to walk through this and figure out where are we at as a committee. Now, specifically process-wise, so that's the substantive ask. Process-wise, the one other thing I want to just lay out for the committee is that we were very blessed that we already had a June 22 meeting on our books to do it, because part of the goal here is to take whatever feedback we get from this committee and see if I essentially have authority to turn that feedback into, hey, if there are areas where we are comfortable with developing more specific language, and if so, what would that look like, that we can provide that feedback to council while we still have council. Council will not be with us for a good chunk of the summer, but we have her for about another 8 days. And so the idea is to try to get feedback to Angie and see if that can then turn into a potential additional language draft or amendment draft that then could be taken to the September 24 board meeting so that we can kind of keep this discussion alive and kind of keep this committee focused on that piece. So that's the idea. Chair, that's my high-level summary. I hope that makes sense. I saw some nodding, so I think I hope that that is an adequate summary. Shelley, Sherry, Angie, you were all there. I know, Ray, you were on an airplane. You did not hear that discussion. And I know, I don't think you were, you have all, everybody has these fantastic excuses, but I somehow had to show up. But anyone who was there in person, fill anything in? Did I miss anything?
No, I think you covered it well. I do want to make sure that we have clarification that TAC is the Accountants Coalition.
The Accountants Coalition,
Yeah,
sorry.
To make sure that we have that.
I was not familiar with the Accountants Coalition, so that is all Big Four representatives?
This is big, it's the Big Four Coalition,
Okay.
yes.
We'll describe it by the other term that they're known by, the Large Firm Steering Committee.
Thank you.
Yes.
That's
Okay.
very helpful. Okay, so
Yeah.
this is a national group.
This is a national group, and
Fantastic.
we are, and essentially they've broken up the country into regions that is assigned to one of the Big Four, and we happen to be in the PwC region, which is when we interact with a TAC representative at PwC. We really are effectively interacting with all the Big Four accounting firms, and they ran this through their internal process as well as through Gibson, Dunn and Crutcher, which is the national law firm that they use. That also happens to be the law firm that AICPA uses.
Great, thank you. That's really helpful. I have to say, I was really pleased when I read this. I think they raise some really excellent points because the guiding principle that we've talked about on all of this is we don't want to regulate further than prior to the APS structure. There is no intent on doing that. And the flip side of that, what really you alluded to this, Martin, when you said we don't really know what the APS structures are. In my research interviews with folks who structure some of these deals, it will become a game of cat and mouse for some. The deals currently are being structured to minimize regulation. So at least that's according to the couple of attorneys that we spoke with who are involved, attorneys/deal makers. So the question is, how do we balance that? I guess this is for Angie. How do we balance that? We need it general enough to capture changes in the way APSs could be structured in the future, not to mention AICPA guidance, which is still in flux, while still not accidentally pulling in entities that we had no intent to be addressed by this document. So I guess I just really wrestled with that, and I don't know that there's an answer, but I just think that that's the elephant in the room.
And that's what, I mean, we talked about when we were no, I can't remember, like, I know I talked with the board about it for sure. We were drafting it. The way we were drafting it was in a way so that we would be able to be more nimble so that we could do things in rule that if you do it in statute, you're stuck with, right? So that's the reason why it is drafted the way it is. It is, and it could I get that there's the initial reaction to a lot of it is probably going to be, this is super broad, but the idea was that through broad in statute so that you can go and rule and make it more specific.
Again, I apologize that I'm not as up to speed on timelines with rules, the rulemaking process. So if we were just hypothetically to leave this exactly the way it is and come up with a draft rule, is that one possibility?
So
I guess I'm trying to understand our universe of where we could be going with this, because I understand the legislative concept intent is to be broad, but not too broad.
Yes and no. I mean, it's
Really two questions that you're asking. And I'm saying this with the utmost respect because you're asking both a process question, right? But I can also sense with my little spidey sense, having sat on too many committees and board meetings with Angie, that she's probably also thinking about the legal question underneath, which is, when do we actually have the authority to do rule writing?
But if this doesn't exist yet, could you have
Exactly. So the bill doesn't even exist, right? Which to me means, okay, I'm going to make Angie very nervous right now. So my hope is, I'll phrase it this way. my hope is that council would say, since the bill doesn't even exist, right? We can simply, as part of our development and, if you will, marketing process, simply say, our intent is to provide for this framework. This portion is in statute. This is the type of stuff that we would consider accomplishing in the rulemaking process, right? That there essentially we have more freedom, and that freedom kind of ironically starts shrinking once we actually have an actual bill, because then it's like, hey, you can't really start the formal rule writing process until you have the authority that the bill provides. But I've probably gone really close to the line of what needs to come from council. Before Angie weighs in on that legal authority question, I do want to answer the process question, because the process question you asked was about timeline, like how long would it take us, right, to get this done? The short answer is usually you need at least 2 to 3 months to get through a rulemaking process. However, that really is dependent on how much work you put into it and how complex those topics are and how many laws and rules committee meetings you may want to run, right? So sometimes we've done rulemaking where we had almost a year's worth of run-up of, before we get into the formal rulemaking, of trying to figure out what all the moving parts are. So it can be a lot longer, but you should not plan on anything less than 2 to 3 months. And if we start from scratch on something as complicated as private equity, I would not recommend doing it that quickly.
Correct me if I'm wrong, but from my prior experience, if the bill assuming the bill goes through the legislature, it's probably going to have an effective date of January 1.
Well, except for we can ask for, so like and I'm not ledge counsel, so I can't speak to like what all they allow, but there are different things you can do through ledge counsel as like what your effective date is. But even if your effective date is, say, whatever it is, so say it's January 1, they can put something in the bill that basically allows you to start rulemaking even before. And so, that's something we can work with ledge counsel on at that point and make sure, because like it's literally like magic language. It's like,
Right.
That's basically like says like you can start your rulemaking even before this passes, right? So you give the board the authority to draft things. And that's like, we did it with the change in the statute, right? The board was like, we're not because you can't motion on things, right? If you don't have the authority to make the rule, there's nothing to make a rule on and it doesn't exist, like whatever, can you put that stuff together, like sort of draft the, sort of flip side to that is remembering, like, in theory, you can put all this together, right? And you can present it and then, the board could not approve it, right? So there's just like, just things to keep in mind, but like the likelihood of that happening is, very slim.
Ultimately, the question before us as we look at the current draft and we look at the TAC comments is, is this something that we want to tie down in legislative? How hard do we want to tie it down? Or is this something that we feel we can address in rule as we go along? And that's going to be a balance of trying to understand not only what serves the board well, but what is a reasonable answer for the profession as well.
Thank you. That's all very helpful background. Thank you.
And I'll add one more thing before Ray jumps into the specifics. In essence, the reason I'm so grateful that we have this now is that this is normally the kind of feedback that ends up coming up like after the bill is introduced and you're already in the heat of the session. So the fact that we have this, that they were willing to work through that process, go through it, be thoughtful, and we have it 7 months before the session starts is actually a huge help and a compliment to us, because it gives us an ability to really be just as thoughtful in our response as opposed to scrambling in January of next year. So that's the reason why I feel I'm touched and very grateful for that opportunity.
With that in mind, I think the right thing to do now is to jump in to the TAC comments right? So I'm going to try and take them one by one and open the floor to comment one at a time. So the first one deals with business organization registration requirement. And the comment from TAC is that we should be more explicit about APS structures that involve an outside owner. And that could be a public company owner, that could be PE owner, it could be, we're really talking non-CPA ownership, right? And at this point, I don't think the draft legislation is specific on that issue, but I'd like to hear comments from the Laws and Rules Committee with respect to just that one specific issue.
This is Beth Spencer, and I just kind of wanted to have a reference in my mind about how Peak handled the professional ethics. And I know it's not the same thing at all, but they did come out and just call it alternative practice structures, which I don't think we've done in this legislation. So and they have a definition as well. And so my thought is, would it be appropriate for us to come out and call it that and have a definition if we were comfortable enough with the broadness of it?
You can, but then, right, then that's in your statute. So if it
Yeah.
changed, right, then you're going back to the legislature and asking for a change again, right?
Right.
They can pivot a lot faster than we can. That's the hard part, right?
Yeah.
Beth, I agree with your point in substance, though. We don't want to be recreating something. I had a similar thought, but I hadn't thought about what you suggested, Angie. I mean, because in substance, I absolutely agree with TAC's comment. This is, we are not trying to do anything but this narrow issue. But the flip side of it is, I guess, in light of what you said, and I am green. Okay. Yeah.
I can hear.
Yeah. So, I mean, an APS is set up so that there can be an outside non-CPA investor, a majority non-CPA investor, because there's for, I don't know, what are we looking at, 30 plus years, it's been fine to have an outside investor so long as they're not majority.
Well, and it's also been fine. Usually they have to be humans. And in many states, they have to be individual people. And the difference with this APS is often they are entities. They are not people.
I'd just like to announce that Jonathan Howell has joined the meeting for the record.
Thank you, Jonathan. Shall I invite comment at this point to see if he has comments?
Interrupt for and give him an opportunity for any comments he may make. That's up to you. It's at your discretion, Mr. Chair.
John, I want to say welcome on behalf of the LRC. We've moved beyond the public comment period, but given you're a member of the public and you just came in, I think I'm happy to interrupt this discussion for a moment and let you share comments that you'd like to share. So I'll give you a few moments. The normal time is you can have up to 3 minutes.
John, welcome. Did you have any public comment for us?
No, thank you, Martin. I do not.
Okay. Thank you and welcome.
Welcome to the meeting. I think we left off with Beth. Beth, did you have more that you wanted to share at this point? Okay.
Would it be possible? I'm trying to, this is Melissa Wall. I'm trying to think about the implications of saying a non-individual partner. If an entity is owned by non-individual partners, then those non-individual partners, maybe it's an entity that is just a consortium of people. I mean, we would still want to apply these rules to those people, wouldn't we? So what would be, I'm just trying to explore this, what would be bad if we said any ownership that is not a licensed individual?
This is Beth Spencer from the perspective of there are firms that do have non-CPA owners, and those are allowed currently. And if we included that, would those suddenly become alternative practice structures that would require 2 licenses? Probably not, because they wouldn't be split. But again, I think it comes back to the comment from TAC of like, it's overly general. It sweeps in a lot of existing circumstances, perhaps.
Could I ask the committee a question slightly differently? And this is both meant to recognize Melissa's question and the TAC comment here, because when I read it as a non-CPA and experienced person in terms of how a public accounting firm is really run, what really jumped out at me is that that comment really focused on, can you please capture the notion that there is an outside investor that's required? So for me, it was less about picking up on the alternative practice definition, but it was really about, is there a way for us, without taking on too much risk, to essentially specify that we're really talking about this outside investor concept? And when I looked at the ledge concept that Angie drafted, and particularly subsection 1, the very first section of it, where we define when a business organization must register with the board, right? I was wondering if here it would be an acceptable level of risk if we can slide in literally just a few extra words that clarify that we're talking about all the things we're talking about now in item 1 in the legislative concept as drafted, but also pull in this outside investor piece. I don't know if there is a way to do that, for example, by saying, if the business organization has an administrative services agreement with a CPA firm and provides professionals, and essentially add in another qualifier about the outside investors in it, because we have essentially 2 qualifiers there right now, right? Qualifier 1 is if the business organization has an administrative services agreement and provides professional accountancy services, right? So I'm trying to figure out, is there a way to do another, if you will, and in there that could capture this outside investor piece? Because, and again, I'm not the expert in the room, but it strikes me that however much APS and PE related APS structures morph, they should always involve an outside investor, right? So us specifying that, I don't think is super risky in this particular case.
What is an outside investor?
CPA investor, a non-licensed, non-CPA investor. So non-licensed individual or firm, right?
Well, would we want, I think we're really talking about outside business organizations, either corporations or other business. We're not talking about in non-CPA individuals.
Yeah, you've got to be careful with that, because right now in a lot of states, when you're not an APS, it's really those non-licensed, they have to be actively participating in the business, right? So that's sort of they can't just be investing money. They have to be providing services to clients or running the business. So we have to be careful not to pull in those individuals, because that exists currently in all the jurisdictions, including Oregon.
Yeah. Which I think, Beth, is exactly why we wrote this essentially almost like as an exception to our statutes. That's why we didn't open up one of the reasons why we didn't open up ORS 673-160, which has all the regular business registration requirements, and we're trying to do this carve out that says, and over here, if these specific criteria apply, then you also need to register. And so we're not, I get what you're saying. I don't disagree with you, but essentially here we have an opportunity to craft a little bit of a different world where it can be something that's not tied to a person.
Oh, I get that part. I'm saying sometimes when Elizabeth is bringing up something, she's pulling in the person that shouldn't be, in my perception, shouldn't be pulled in. And that's where I'm asking to be careful.
Yeah, I appreciate that, Beth. Thank you.
Yeah.
About outside investors in what other form other than an individual person, right? And that could be a C Corp, or it could be, I mean, there's any number of business organizations or other organizations.
Business organization, which is already in statute, is business organization means any form of business organization authorized by law, including but not limited to a proprietorship, partnership, corporation, limited liability company, limited liability partnership, or professional corporation. So that already pulls that part in by saying a business or any, but that's just like, I'm not sure, like, so would you say a business organization? What? Yeah. What's the yeah.
Business organizations that are to some extent owners in the CPA firm.
But they aren't, right? They're not owners in the CPA firm because they're owners.
Have some ownership in the attest firm, and they probably have ownership in the non-attest firm.
No, they can't have ownership in the attest firm. That's why they create the alternative practice structure. The attest firm is basically a shell company with real CPAs.
Have minority ownership. They can have minority ownership in the.
They can, but it would have to be a person involved in the business. It can't be a business entity on the usually under the traditional firm license. It has to be a human.
So here's an idea. If our concern is not inadvertently kind of scooping up other entities that already exist, that are already registered as firms, but offering, providing these similar services, those existing structures, could we just put in an exception here where it says, if you meet this definition, unless you are otherwise registered, right? Then this would apply. So if you already are registered as a CPA firm under our other statutes, this doesn't apply to you. You're already falling under the board, you're already regulated. We don't need an additional layer of registration if they're registered as a firm in another way. Would that kind of preserve the carve out and, keep us from stepping on the toes of the existing entities that we're seems like we're kind of dancing around?
So, Amanda, I'm pretty sure we can do that. I will say that the way I understood the concern, which hopefully makes more sense to those of us in the room that operate CPA firms, is that I thought that when I read this, that this is about, hey, what happens if you have CPA firm so-and-so and they do, for example, internal offshoring and have a back-end operation in another state or even another country, right? You don't have an outside investor. They simply have, essentially, they operate through an internal service agreement saying, here are the people back in India that are going to do our back end do some version of back end service for us and then provide those services back for us in return for some form of payment. They don't necessarily want to have to now register them because it doesn't really fall into the category of you don't have an outside investor, right? And those entities wouldn't be registered already. They're simply an offshoring entity that firm uses right now, right? So how do we, at least that's the way I understood it, is that the worry is, are we starting to capture some of those more internal arrangements and making them subject to registration. That's the way I understood it.
So,
I mean, the way that I read, sorry, this is still minute. So, the way that I read this, I mean, it is broad enough that it seems like it could potentially also bring in other type of independent services, like independent contractors and things that are a much smaller level. Potentially temp agencies or other subcontractors, or even if, for example, if I'm an individual independent contractor, but I'm providing my services under an S corporation. So the agreement is with my S corporation and not necessarily with me as an individual. Would that potentially be brought under this umbrella? And it seems like it's, a lot of these, I'm assuming, would be exceptions that would be identified in rule to clarify those things. But when I read this, that was, my brain went to, a lot of these other smaller entities that might inadvertently be caught up in this as well. So I guess that's kind of where I was thinking as far as the, like, if you're otherwise licensed, would potentially preserve some of the, exclude some of those as well.
So I guess my question is, we talk about a business organization, and the business organization, Angie, as you've defined it, captures a lot of what we're talking about. So the question is, do we need more specifics here? Or does the specificity really need to come in rule? And I'd like to hear your thoughts on that.
I am really sensitive to this not becoming a potential for over-regulation. And so it feels like there should be, so this to me feels like one of the spaces where we need a little more specificity. I think it was Beth that you said, no, it was Amanda that said, could we just scope some things out? I had actually been going the other way. And what if at the very end, and I'm trying to think this through in real time, we added something like, and has one or more outside investors or ownership's interests held by non-licensed entities associated with the structures. Does that get us there? Yeah.
Yes.
Yeah. I mean, we're basically using their language. Because I would not want all of these other potential service providers to get swept up in this. To me, that was one of the biggest points that I felt like we've got to deal with that.
Sherry, I kept coming back to that portion of the paragraph as well. It seems pretty clean.
Outside investment and or non-licensed entity. And it's using their language seems to be, as long as it makes sense to us.
Oh, I'm sorry, Elizabeth, we can't hear you.
Sorry, hit the button one too many times. This has clearly been vetted through this group's attorneys. And so it seems to me that that's maybe a good place to start. Again, let's just make it, all we're trying to say in this ledge concept is we want to keep the status quo. So there's all kinds of form changes that are being made. We want to capture the substance of what was there before. Mm-hmm. There's a reason I did not go to law school, though. That's very clear to me. So pulling in their language. Yeah.
Martin, are you speaking? Someone's speaking and we're not hearing.
So essentially you're talking about the very first sentence after the word applies, where the business organization has one or more outside investors or ownership interests held by non-licensed entities associated with the structure. That's the language that I think you're talking about, pulling in and utilizing and seeing if we can add that to the definition in subsection 1 of the current draft concept. And then
I like that.
would that, if necessary, we could then, if we were to do that, Angie, we could then, if necessary, go further in rulemaking if we needed to then define what an outside investor is without making the statute too complicated, if we have to define it. I'm not saying I would like to go there. I'm saying that if that addresses your concern about using an undefined term in that language, because we currently don't have a definition of what an outside investor is in statute or rule, because I think that's kind of where your part of where your concern is at right now. But I think it would go a really long way to address that concern on the outside. So I
have a question. I'm just thinking about around the state, we have, in some smaller communities, areas where basically the CPA firm is made up of, let's say, two partners. So it's a majority, 51% for the CPA, so 49% or what have you for the, let's just say, an enrolled agent as an example. Okay, so check mark. Now let's think about a few instances, like I'm reflecting on a call a few years ago where someone said, when our community is so small, when I retire, I'm taking on someone else. They're going to move up in ownership. They are not a CPA, but they're a licensee in the state, right? So does that mean that, I'm just thinking out loud here, when that CPA ends up taking on that person, even though they don't, let's just say they both have 50-50. So they would fall under this, as we're saying, because otherwise their choice would be, if it's 50-50, it's no longer a CPA firm, right? So with the 50-50, they could still remain a CPA firm. They would just, even though there's only two owners, they would then fall under this. I'm just
sweep in business organizations.
Right.
We're not trying to sweep in
Any individual. I'm just talking it through to make sure that I haven't missed something there. Unintended consequences. Okay.
So, Sherry, sorry, this is Amanda. So the my understanding is it sounds like yes, in theory, under the definition of business organizations, that could, they might be included there, but they're not then going into the next section, having an administrative services agreement that would require this type of licensure. So even though they might fall under the definition of the entity, they're not doing that type of work to have to that would be required.
Thank you. I realize I'm being creative in my thinking, but just applying some of these things, because I keep thinking about avoiding unintended consequences. Thank you.
So, so the way I've written it out, like just for an idea. So based on what it was written right now, is that a business organization must register with the board as a professional accountancy business services organization if the business organization has one, an administrative services agreement with a CPA firm, and I think it actually would be A, B, and C, but whatever, you get my point. 2, provides professional accountancy services in Oregon, and 3, the business organization has one or more outside investors or ownership interests held by non-licensed entities associated with the business organization. Because I don't think you'd want to say structure, because that would be like a whole other word of like what's structure.
Yeah. Okay.
I think where I was getting creative was focusing on the word entities, sort of. That's really more business oriented than individual, but. Thank you.
Angie, I appreciated your comments, and I appreciate what you've done to kind of put A, B, and C there, which I think works. Does that capture our concerns? And if we went down that path, do we think that to me, that sounds like a strong improvement to it. I'm seeing heads nod all the way around. I guess the next question I have, Martin, there's a point at which, as we go through this, you said we need some motions. Do we need a motion, or do we just leave the discussion at this point that we like doing the A, B, and C and drawing in the TAC comments?
So I like keeping things pretty simple. And I
Yeah.
do think that it might be easiest for us, given that we're dealing with so many different topic areas, if we do motions as we go.
Yeah. Right.
So I think it would just be easier right now to simply say, could I have a motion to amend subsection 1 of the legislative concept with the TAC language as discussed? And the best thing would be if somebody could simply now say who's on the LRC, so moved.
Melissa Wall, so moved.
All right. So
Elizabeth Ulmer, second.
Elizabeth Ulmer, second. Okay, let me go around and poll the committee. Sherry,
Sherry McPherson, aye.
Elizabeth,
Aye.
Amanda,
Amanda Fells, aye.
Melissa,
Melissa Wall, aye.
Beth,
Beth Spencer, aye.
and Ray Johnson, aye. It's unanimous. Thank you, and thank the committee for the quality of your discussion. The next issue is around the language of professional services, and that those professional services should be limited to external clients as opposed to services that would be rendered, perhaps from one side of the organization to the other, which quite often happens, I would guess, a fair amount. So let me open that second issue up for comment. Once.
I kind of paired, this is Beth Spencer, I kind of paired that professional accountancy services limited to external clients, but then they also provided a point at the very bottom of the document that said the definition of professional accountancy services creates a new defined term that may cause interpretive ambiguity, because apparently, in statute or rule, we already have several related concepts, including public accountancy services, attest services, tax services, and professional practice. So my question kind of steps back, and is it our intent to create a new definition here? And if it is, that's fine. But I just want to know if that's what we intended. And then if we did, does it harm it at all by further clarifying it's external? Because I do think that's a good point.
So that's why it says professional accounting services for the purposes of this section. So in legal speak or whatever, like when you're looking at statutory language, that's why you say for this. So it's only for this section. It's not for the whole statute. It's just for this section.
Okay, perfect.
I think then leaves the issue of what are the thoughts of the committee around essentially responding to the ask, which is, should we add in that additional clarification that we're talking about that type of service being provided to an external client rather than an internal client?
So this is Amanda Fells, and I guess maybe what I would like is maybe some more understanding of what the internal administrative entity might look like. Like, what would that relationship look like? Because my concern is these two entities that were, on the APS structure are already so regulated that if they're, so related, that if we just, looking at the definition of internal and external, like how, I guess I'm just not familiar with how that internal operational entity might work and how that might not inadvertently create a loophole for how they're setting up these structures and architecting them from the beginning. Sorry if that wasn't clear.
This is Elizabeth. I think I immediately thought of something that I remember learning years ago, that Deloitte has a separate legal entity that all of their administrative professionals work for. And it does nothing but provide, this entity does nothing but provide exclusive services to Deloitte. So that's a big difference because, you know, these are admin, recruiters, HR, all of those folks are employed by a separate legal entity. We don't want to sweep those in. We want to make sure that the auditors who are employed by the PE-owned non-attest entity and are leased to the attest entity. That's the type of services that we're trying to capture here, not a separate legal entity that provides only internal HR services. And that's the point I believe that they are making. They're coming from that perspective. So once you start thinking about, you know, every non-client service professional works for another entity, that starts to make sense why they phrased it the way they did. I don't know if other Big Four that work that way. I just happen to know that Deloitte does.
Okay. So essentially, it sounds like PE is doing something similar, but only with professional staff, right? Essentially.
Yeah, there's almost nobody sitting inside of the attest entity in an APS. I mean, it can vary a little bit, but that whole idea is you take all the assets out of the attest entity, all the assets, including the people, sit in the non-attest entity and then are leased over to the attest entity.
Right.
But then they are also providing services to the public, like tax and consulting and all those other things. So that's what they're trying to point out, that this alternative practice structure is a business that's picking up all the clients that the other firm used to have. And now we've just segregated off the attest function to them. And we're going to sell these to the public because we're not regulated anymore. And
yeah, and I think you're right, Beth. And I think this is part of what we saw Peak wrestling with as well, is that they're trying to deal with these entities that in the long run are providing services to the public. That's what we're trying to capture.
So it's less about whether or not the entity that owns the staff is internal or external to the structure. It's more about what those staff are doing. Is that the clarification?
I think that's correct.
Okay.
So am I hearing that the committee is open to slightly editing our administrative services agreement definition in subsection 2 to reference that external concept?
yeah, otherwise I think we're gonna pull in. Even though in rule we can try to limit it, the people here now writing rules might change in 7 years with a new committee, and they could broadly pull in any administrative services agreement. And I do think it is a little too broad. Because if you think about it, the way APSs are set up now, if we were to add that and say, okay, it's only if the other business organization is also offering these professional accountancy services to the public. Well, if they're like, well, then fine, we don't want to be licensed, we'll offer them through the accounting firm. It's like, well, then they're legislated, right? They have accountability there. So I don't see that as a negative, because there's nowhere they can go and offer to the public unless they completely step away from the attest thing. Then they wouldn't be regulated, I guess.
I guess the question I'd like to hear around the table is, as drafted, we're talking about the administrative services agreement and references sharing of employees between a business organization, the CPA firm, or as further defined by rule. And so I guess the question is, does this committee think we want Angie to try and specify that we're talking about that administrative services agreement is provide, we have people providing services to the public, not just internal services within the organization?
Yeah.
Or are you comfortable that we can solve this appropriately in rule? How would you like to proceed?
Elizabeth, I think this is a really pivotal issue. I think we need to define the scope of what this is in statute.
So I actually have a specific suggestion, and I don't know if that's gonna, quite frankly, cause you gray hairs, but there's by you I mean Angie, our counsel. But when I look at this, I'm actually wondering, even though that's not exactly what TAC suggested, if the cleanest way to capture the limitation to the external client is actually not with an amendment to Section 2, but to Section 1. And that would get us to the same place and be cleaner. And so when I look at the original language in Section 1, which I know we've already just passed a motion to kind of further refine it, but when it says toward the end of the current sentence in subsection 1 that's in material and says, and provides professional accountancy services in Oregon, right? Simply say, and provides professional accountancy services to external clients in Oregon. And if we actually slide it into that definition rather than the administrative services agreement definition, doesn't that get us to the exact same place?
This is Elizabeth. I might be overthinking this, but we've determined that the attest entity is not an external client. Right? Because there's an administrative services agreement.
Not be an external client.
But
services they provide.
User of the services. Okay, great. Sorry, I'm overthinking.
Yeah. But does that make sense? Where my head is going is that it might be cleaner to actually define this external issue in Section 1 rather than Section 2.
Can you say it again?
Beth, what do you think?
I like it. I think that's a good solution. It sets it up right away, so you're not reading further to understand scope. It's kind of all right there.
So council just asked that I repeat this. So what I'm looking at is the original language that we had for subsection 1 in the legislative concept toward the end. So this is on the line 3 of subsection 1, and provides professional accountancy services, and then I would insert to external clients and insert, go back to what it says there in Oregon.
I just want to make sure I know what you're talking about. Sorry, continue.
So that was a suggestion, and it's not meant to override what we did by prior motion to then have this other language that it doesn't disagree with the prior motion. It would add in those 3 extra words, but it would do it in subsection 1, because I think that might be, in terms of reach, clearer than if we slide it into the administrative services agreement definition.
Martin, I like the putting it there. I do think it makes it very clean. Are we running into then having to define what an external client is?
Maybe we want to say clients, just not external.
Yeah, or would we say members of the public, right? As opposed to necessarily external client or something along those lines. Something that would be.
Because I think we already have client defined in statute.
Yes, we do.
Client definition.
But turning the word external in there kind of can sometimes it confuses people, right? Like you want to kind of be consistent in how you use your term. So let me look at so if we just said to clients.
Sorry, Angie, I'm having a very hard time hearing you.
I'm sorry, I'm not close enough, probably. I was just saying exactly what you were saying that Amanda was talking. So yeah, like instead of saying external, saying just clients, but let me look at what the definition of clients is. So you guys know what everything we're talking
It's pretty, I don't think it fixes it because it includes any person or entity who receives professional services.
who agrees to receive, right? They're agreeing to receive it.
Right? Wouldn't that inherently though bring in, if we just leave it there, wouldn't that bring in then the attest firm as a client of the non-attest firm?
So you think it,
Person who agrees with a licensee or employer of a licensee to receive any professional services.
I think it changed this last year. So now it says client means a person who receives professional services or a person who agrees to receive professional services. Is what the current statute says.
Yeah, that listening to that to me means that we better throw in the external.
Okay.
Agrees. So if you don't agree to receive, I like the external in there.
Yes, but it's to me, it's not about the agreeing to receive part. It's recognizing that professional services can flow on a purely internal basis without touching an external client. That's really where I think the crux of the issue is. But I think it sounds to me like we actually have an agreement that it sounds to me like, and maybe we need to.
Wait.
Okay. We thought we were there. Hang on.
I wonder if it doesn't make sense to put it, I think maybe you might want to put it down and because who has in this scenario, the business organization is the APS, right? It's the APS. And the APS is not providing the services to the external clients, or are they?
They're leasing the personnel, the facilities, to the attest entity, which in turn is providing services.
But they're also providing services externally, the way we define it, by doing wealth management, tax, and all the other stuff to external clients.
You've got services going through the attest entity and then services that are through the non-attest APS.
Right. But bottom line is, that's what we're interested in. They are providing services externally. The concern that TAC is raising is, are you capturing in instances where it's a purely internal service provision with no external client on the other end?
But I thought a lot of them didn't actually do that. Like didn't actually have an external client.
Oh, yes, they do. They have all the non-attest services that's the whole point of the APS is so that you can take the one of the objectives, so that you can have an entity that provides non-attest services. So tax, wealth management, anything, consulting services to external clients and not be regulated. That's where the big profits are.
Because the other thing, I was like, could you add it to because I'm worried that we're tacking things onto the wrong side, but, and would this also just something to think about too? Like, so that's fine. I have that draft language in there, but also would it be administrative services agreement? So going to that definition for the purposes of this section means any agreement between a business organization and a CPA firm that references the sharing of employees between a business organization and a CPA firm to provide professional accounting services to an external client. So either way, I mean, or both. I guess I just want to make sure where we're putting it, it doesn't have an unintended consequence of attacking it to the wrong side.
So are you saying you're still on board with amending section 1 with the external piece?
Not my decision. This is your guys' decision. I'm just
Whoever's
throwing
talking.
out some. Yeah.
We can't hear you, Martin.
Sorry, we're trying to understand what your advice is,
Saying,
Angie.
like, where does it make more sense to put it, in 1 or 2?
Okay.
You say it makes more sense to put it in 2.
So it sounds like if we put it in two, we are limiting the scope of what type of administrative services agreements are covered, right?
Right.
If we put it in one,
You're
we're
only tying it to
limiting
one side.
the registration requirement, right?
Right. So by putting it in two, you're tying it to the term administrative services agreement. By putting it in one, you're tying it to who needs to register.
Okay.
Mm,
My instinct is that it better fits in one because that way we're not trying to parse what type of administrative services agreements people have or redefine that term. We're just saying if you're doing this and you're providing these types of services, right, under the structure, if you're a business organization doing this, you may need to register, and then you kind of get into, or you do if it's to internal clients only, you don't even get past one, right? Because step one says it's to external clients. So it doesn't matter what type of administrative services you have after that or agreement you have after that. Because if it's only internally, it doesn't apply, right?
And I like putting it, this is Elizabeth, I like putting it in one because that scopes what we're talking about. Two,
Mhm.
3 are both further defining terms that are in number one.
Mhm.
So as you said, I believe, Amanda, that means that you can just read through one and decide if this applies to you or not.
All right, I'm trying to get a sense of the room. Do we generally want to follow Martin's solution and amend one to be talking about professional accounting services to external clients?
Go number one. Go number one.
Go number one.
I
Yeah.
think what Melissa's trying to say without trying to put words in was I think I'm hearing a so moved.
Let me read it. So make sure. Let me read it to make sure you guys have what you want. So, okay. So one, a business organization must register with the board as a professional accountancy business services organization if the business organization has sorry, and I said one before, but I meant A, B, and C. A, an administrative services agreement with the CPA firm. B, provides professional accountancy services to external clients in Oregon. And C, the business organization has one or more outside investor or ownership interests held by non-licensed entities associated with the business organization.
Full go, Melissa.
So moved.
Right, second.
Beth Spencer, second.
Beth Spencer, second. Okay. I'm going to go around the room and take a vote here. Sherry McPherson.
McPherson, aye.
Thank you. Elizabeth Ulmer.
Elizabeth Ulmer, aye.
Beth Spencer.
Beth Spencer, aye.
Amanda.
Amanda Fells, aye.
And Melissa.
Melissa Wall, aye.
And Ray Johnson, aye. It's unanimous.
If I may, one logistical issue before you get into the next one is I became aware just before this meeting that our committee member, Ms. Melissa Wall, needs to drop off at 1. So I would like to ask for planning purposes, since it's 12:18 right now, that we defer any breaks for lunch until 1 so we can get through as much as possible while we still have Melissa, if that's okay with the chair.
And with me, I think we can manage. So let's just keep on rocking and rolling here. So I guess the next item goes down to the question raised by TAC, is the term administrative services agreement overly broad? Now, we've kind of already address this in some respects, because a lot of what they're talking about, and maybe this folds into, let me go back and look at theirs. I think we've, in many respects, solved this already with our comment with respect to external clients. But the question is raised, is it have we appropriately solved that with the amendments that we've made already?
Great way to phrase it, because that's kind of where my head is at. As a non-expert, I want to hear from the experts in the room, but as a non-expert, it feels like I think we fixed this already with what we've done already. But that's, I really want to hear from the committee whether the committee agrees with that.
I think we have fixed it. This is Beth Spencer, just because, you know, we've taken all of this concern about pulling in things we don't mean to and said, no, it's going to be these folks without too much extra language.
And my sense, keep us moving, but all right, speak up now if you think we need to address this further. But my thought is the amendments we've already made really address this issue.
Ask Angie a hypothetical question. This is Elizabeth. So, if we think about all the different services that CPA firms tend to perform, so that's, you know, attestation, compilation, audit, advisory, you know, consulting services, financial advisory, tax. Am I missing something? Right? We've got all those different services. Are we now putting those under the umbrella of professional accountancy services? Right? Is that what we're trying to do here?
I mean, it's already listed out there. So it says professional accounting
Right.
services for the purpose of this section means services arising out of or related to the specialized knowledge or skills associated with the certified public accountants, including but not limited to attestation, compilation.
Yeah.
And it goes.
So Angie and Ray and Elizabeth, I think what the issue here is there is a confluence between two things. One is what Angie just pointed out is
Yeah.
essentially a broad definition that applies to just this separate thing that we're writing, right?
Right.
But I think what you may be referring to as well is that we already also are one of the few jurisdictions that has a very broad definition of what
Yes.
the practice of public accountancy is, that draws in all of those elements, which means that this is actually, from my perspective, not really a policy change in terms of where the board is at, because we are one of the jurisdictions that have hung on to a very broad definition of what the practice of public accountancy is. So I don't think it's a departure in this, or to go back to that core concern that the committee has, can we make sure we don't regulate more, right, than the space we're currently regulating? Well, we are. The whole reason the board went down the road, well, not the whole reason, but one of the core reasons the board went down the road of even seeking this legislative concept is because we felt we were losing jurisdiction over part of our ability to regulate what the board has traditionally defined as the public accountancy space. Does that make sense? That we are?
Yes. And that's exactly where I was coming from, was trying to reconcile that. So I guess the question is, why are we using a new term?
Can I that for a moment? And because there's another specific comment later in the TAC comments that come to this.
Okay, that's fine.
But this particular TAC comment is the term administrative service agreement definition is overly broad. I don't want to get into the, you know, and from my perspective, the minute we've talked about services provided to clients, external clients, I think we've already addressed the things that they're talking about here. So I think from my perspective, and I'd like to hear contrary views, but I think the two amendments that we've made already fix this particular problem. I think we've narrowed it down. And I'm seeing heads nod. Let me just ask for a thumbs up or thumbs down for those of you who are online. Thumbs up, thumbs up, thumbs up. Elizabeth?
Yeah, I think I was a
Yeah. So if I can, in the interest of time, I'll say I think we've resolved this and we're going to move on to the next topic.
From a public meetings law perspective, we didn't take a formal motion, but I just wanted the oral record, because the oral record has to align with the visual record, just reflect that all committee members essentially gave a thumbs up to us not making further language changes in response to the third comment by TAC on the definition of administrative services agreement. I just want to put that on the oral record very clearly, Mr. Chair, and with that, you can move on.
Thank you, Martin. So I'm moving on to the next comment raised by TAC, that APS agreements typically involve much more than shared employees. Clarification of this should be explicit. And so I'd like to hear the thoughts of committee members on this specific issue.
I agree, because I think, the real crux of all of this with the administrative services agreement is, even if you don't have some of the things like board members shared between the two entities, the minute you have an administrative services agreement that contains a fee that is charged, there is the potential for undue influence. So the question that we have in my mind is, how much do we need to define what is included in an administrative services agreement?
May I tag on a question to that might also hint at a potential solution? So when I look at this and the comment that APS provided, I would love to ask the experts on the committee of what would happen if we go into the administrative services agreement definition that you currently have in subsection 2 and simply, which might be deceptively simple, insert, and I'm now direct quoting, starting on line 2, and a CPA firm that references the sharing of employees. And I'm going to stop there. And my proposal is to insert employees and employees or services between, and then resuming again. So only insert the word or services. So not limiting it to employees, but say employees or services, and then return right back to the text as we have here. Would the insertion of those two words, employees or services, broaden this enough to address what the TAC concern is that if you focus it on employees too much, you're not going to really hit the mark. Would that solve the problem? I'm getting a no.
I think you're still, Elizabeth, I think that you're still missing the facilities piece, the other pieces of infrastructure, because all of the IT is going to be sitting at the non-attest entity, and the piece that there's a fee charged.
You could pick up, I think the one issue that they bring up that I think is critical here is paying a service fee representing a portion of the revenue.
Yeah.
Yeah, I think there's a variety of things that could be appropriately included in that administrative services agreement.
I can take a stab at what that would sound like. So and a CPA firm that references the sharing of employees, comma, services, comma, facilities, comma, or other infrastructure between a business organization and a CPA firm for a fee. And that captures all of it, I think. Am I missing something, Ray?
Run back through that one more time.
Well, I think you have employees, services, facilities, and infrastructure. The only other thing I could think of is I do not have enough detailed knowledge about where any offshored services would fall into that. So my understanding is a lot of the APSs, they're setting up their own offshore service centers as well that must be used by the attest entities. So does that fall under infrastructure?
I'm not,
You said employees, services, facilities.
Employees, facilities, infrastructure, which is their systems, because the systems are not, and there's nothing on there's almost nothing on the balance sheet at the attest entity. So those are sitting at, and that's quite expensive now. That's a big piece of what's being leased over.
so just to be clear, what I'm hearing is since the word employees is part of the existing definition, that it essentially would be an insertion of comma, services, comma, facilities, and infrastructure, end insert.
Yes, and then work in the fees piece for a fee.
For a fee.
For a fee. So you've got to get more inclusive with the services and add in the fee. And my question is just, did I catch all the services?
From my perspective, that sounds really good because I don't think that it matters whether any one of those pieces involves an offshore entity because the location doesn't matter. I think the issue is it part of that definition of employees, services, facilities, and infrastructure?
Because if you're using a offshore service center, that's employees, right?
Mhm.
The IT systems fall under infrastructure. The
Mhm.
physical facilities, the computers, all of that, I think that captures it. I mean, the idea is everything that you need to run the firm is sitting at the non-attest entity and is leased to the attest entity, except for the handful of partners that actually own the attest entity.
And then overarching everything, this is Beth Spencer, is that we've already said, and that other entity is serving external clients in Oregon. So we
Yes.
don't sweep in
Yes.
non-client facing.
I'm going to read the whole thing. Administrative services agreements for the purposes of this section means any agreement between a business organization and a CPA firm that references the sharing of employees, services, facilities, and infrastructure between a business organization and a CPA firm for a fee or as further defined by the board in rule.
Shouldn't it be or?
Yes.
Okay, not and, infrastructure or.
Because then you would have to do all of those things.
Right, yep.
Sorry, do you mind just after correcting that, reading that one more time? Because there is at least one committee member who's dying to say so moved right after you say that.
Administrative services agreement for the purposes of this section means any agreement between a business organization and a CPA firm that references the sharing of employees, services, facilities, or infrastructure between a business organization and a CPA firm for a fee or as further defined by the board in rule.
I think that's good from my perspective.
Can I offer one other alternative?
Mm-hmm.
I guess I just keep thinking, what services could exist that didn't get captured with that laundry list?
That's why it says or further defined, right? So you can
Okay,
put
so
the-
that'll take care. Yeah, okay.
Got it, because we could further define in rule.
Because the other approach is just employees or personnel and operational infrastructure. And then that just captures all of it.
Sorry, what else? Do you want me to add more?
I don't know. No, instead of
Okay.
that, if you just want it, I
Oh,
mean,
sorry.
it's a choice whether you want to list it or just provide the broad category. So it could be leased employees and or operational infrastructure necessary to support the CPA firm. I don't know.
But then you gotta, what's the least employee?
Okay.
I think that the initial piece that
Goes back to tax language.
Angie
Really.
read is probably a little bit less risky.
I'm comfortable with Angie's original
It's
proposal.
really.
Yeah,
Which is really Elizabeth's.
It's original.
Yes. It's really your original language. So give yourself some credit. Yes.
I like the original, I think, because it's very clear.
Mm-hmm.
Yeah.
Straightforward.
read it one more time.
Administrative services agreement for the purposes of this section means any agreement between a business organization and a CPA firm that references the sharing of employees, services, facilities, or infrastructure between a business organization and a CPA firm for a fee or as further defined by the board in rule.
So moved. That's Spencer.
Okay,
What we were looking for.
adopt the language is just read by Angie.
Yeah.
May I ask one question,
Yeah.
please? Uh, shoot, now I lost the place that we're talking about.
I think we're in part 2, administrative services agreement definition.
Okay, thank you. I was getting confused in part 3 for a second. Okay, so my question is, Angie, could you please read after and a CPA firm, or I think I missed a word that had been added.
And a CPA firm for a fee or
Okay,
further defined by the board in rule.
thank you. Thank you. I'm good. It was for a fee that I missed in there. Thank you.
I missed that earlier too, Melissa. So I'm really glad we have it in there. So do we still have so Beth, I think your motion is still on the floor, right?
Yes.
But that means we need somebody who's willing to
have
do a
to-
second.
Beth has the motion,
I'll second the motion.
second by
Melissa.
Melissa. All right, let me go around the room again. Sherry?
Sherry McPherson, aye.
Elizabeth Almer, aye.
Beth?
Beth Spencer, aye.
Amanda?
Amanda Fells, aye.
And Melissa?
Melissa Wall, aye.
Ray Johnson, aye. It's unanimous.
I just had a comment/question, just to clear this up in my mind. So the way that we listed out, we're saying employees, services, facilities, or infrastructure. So in my mind, are we saying if there is no leasing of CPAs, but only the infrastructure that we're intending to have them register? Because the or changes the meaning for me.
It can be interpreted that way, but an and we can't do because then you would have to have all of those elements and we wouldn't necessarily have it.
Mind the broad. And keep in mind that the broad idea here is that it still has to mean in the context of everything else that we've done that
Yeah.
ultimately a service to an external client for a fee has to exist.
Yeah.
Right? Not an internal only arrangement, right?
Yeah.
I understand your question. So you want to make sure, I think I'm interpreting what you asked. You want to make sure that if there is a third party that provides office space, they're not going to get swept in. Right. And that's because of, you only get to this point if you've already met the definition of one, you've already met the terms for 1 and 2. So I think we're safe, right? around
I,
the
I think so. I just wanted to point that out and make sure that was the intent
Yeah.
when we changed it to or. That
Yeah.
makes sense. Makes.
Okay, we move on to the next one about the comment, or as further defined by board rule. I guess I'm going to jump in here for a moment. I think given the way we've tried to limit things at this point, we've already added more specificity. I think there comes a point at which you have to have the ability to further define and rule. We know we've got some moving targets out there. Board rule is an important part of our regulatory process. Given that we've already narrowed things, and particularly given this last discussion, I find myself very comfortable with as further defined by rule, because I think that's something, that's discretion that the board has to have as it goes forward. And that's my own thoughts. I welcome the thoughts of other committee members.
I'm thinking, okay, let's just say something pushes out there so much in artificial intelligence. That's an area where maybe at some point the board says, hey, we have to do something. We wouldn't be able to make that change without going back through the legislature, which could be 2 years. So I am in agreement with you. I kept thinking about what's a topic that might rise up. I mean, some of these topics, if we go back 80 years, they weren't even here. So we're not going to be in place that long before there's more changes.
Given the changes that we've already made to try and be a little more explicit about what we're trying to do, I'm comfortable here allowing I think it's important to explicitly give the board the authority, the rulemaking authority.
This is Melissa Wall. I agree with what Ray and Sherry have said, and I would move that we consider this particular comment to be fulfilled so that we can move on to the next thing.
Let me take that as a motion, Melissa. Do I have a second?
Amanda Fells, second.
By Amanda Fells. I'll go around with a quick vote. Sherry?
Sherry McPherson, aye.
Elizabeth?
Homer, aye.
Amanda?
Amanda Fells, aye.
Beth?
Beth Spencer, aye.
Melissa?
Melissa Wall, aye.
And Ray Johnson, aye. Unanimous. Okay, the next and really the final comment here deals with the definition of professional accountancy services, which is a little different than our definition of practice of public accountancy. So I want to open the floor for the discussion. Does it create ambiguity? Is this helpful? Is this challenging? What challenges does it bring to us?
Admit I just felt a little bit confused with throwing in another definition, and I worry that if we already have a different definition than much of the country, throwing in one more term is problematic. Is there a way we can go back to using our own definitions?
If I may,
Is
just
there-
for background.
Yeah,
I'm sorry.
that'd be helpful.
If I may, just for background, this is actually even more challenging than the TAC comment indicates, for the following reasons. So first of all, let's start off with the good news. Elizabeth, you're absolutely right that we have an existing definition, at least at the rule level. I'm not sure that it's in statute, but at least at the rule level of the practice of public accountancy. And so we could go back to that and just say, oh, we're just aligning this with what we already have, at least at the level of rule, but then we're also tying that down. Here's where the problem comes in. There is absolutely no consistency among the 55 jurisdictions about how they approach the practice definition or if they even have one. And I believe it goes back slightly more than 2 decades where at the national level, the NASBA, the National Association of State Boards of Accountancy, on advice of their then counsel, removed the definition of what existed at that point of what the practice of public accountancy was from the Uniform Accountancy Act. So the profession literally over 2 decades ago gave up on having a true north definition of what the practice of public accountancy is, and now is actually re-engaging in, at least on the NASBA side. I'm not sure yet whether it's on the AICPA side of the Uniform Accountancy Act, which is a joint committee at the statutory level. But at least on the NASBA side is starting discussions of whether they should revisit having a common definition of what the practice of public accountancy is. That's a really, really big lift. I'm not so sure that there will be the wherewithal that now that it's been removed for 2 decades, it will be able to get it back in, because quite frankly, in a lot of jurisdictions, that will be viewed as you're expanding the regulatory framework in an environment where across the country that is going to be a very hard sell, right? Which also means for us, good news first again, yes, we have an existing definition, and one very legitimate question to council will be, could we simply tie it to the existing definition that we already have? But with respect to the national picture, we are in a no-win situation. I can't sugarcoat this. We're in a no-win situation because we don't have something we can tie it to. And even if there is something that emerges years from now, we won't know what that is now.
I guess I would say when I read this, then I went back and read our definition of practice of public accountancy, and I understand we're broader than the rest of the country. And I understand some of the history that got us to where we are. But the definition of practice of public accountancy is pretty clear about drawing the attest arena in. It's pretty clear about drawing tax in. It talks about a variety of services where we have professional standards. And from my perspective, I was more comfortable with that. And I don't know what the discussion was at the board, where the board felt we wanted to draw in a broader definition, because it draws in more the management advisory and financial advisory. There's not the same level of professional standards around that. I think we've widened the definition here. I was a little more comfortable with the definition that we currently have, even though it's broader than what a lot of the country has.
Okay, so that part makes it now clear to me. So you're essentially saying you would be more comfortable if we had a definition that either is or is very close to what we currently have in rule rather than a new one.
So this aligns with what just happened in the legislature. So the reason why when we wrote it, we said this is what professional accountancy services are, is so that it fits right with saying like these are the professional accountancy services that are provided through these administrative service agreements, right? So I'm trying to tie those things together. But we do have in statute, what does professional mean? And
Yes.
professional means, it's basically the same thing, right? So it says professional means arising out of or related to the specialized knowledge or skills associated with the certified public accountants and public accountants, including but not limited to attestation, compilation, audit, management, advisory, financial advisory, tax or consulting services, or issuance of reports of financial statements, or as further defined by the board. So that's already in statute. So it's trying to mirror that language here of what is in statute. And then, and what you could do, right, is you could just say professional accountancy services means, professional means basically what it says above in professional, and leave it at that. I just think that sometimes it's nice to have it there so that people know what professional actually means, but you could just refer back to the professional accountancy services is what is found in definition section sub 14 professional or something, something along those lines.
Essentially,
If we already have this definition in statute,
yes.
then
It's just professional, though. It doesn't say services.
Right.
Yeah.
So, yeah. It just says it defines professional as meaning this, and this says professional accountancy services. So I was just trying to make sure we don't have like multiple things in the same statute that are different, right? We want it to be the same. And you could very easily just say professional accountancy services.
So
Now,
Defined in subsection 4, whatever, 14.
sorry, this is Amanda, and maybe I'm confused. Are you referring to the definition of practice of public accountancy, or is there's a different definition of professional accountancy services somewhere else?
So we do not have a statutory definition of the practice of public accountancy. We have a definition of the term professional. So it's a 617.
Oh, okay. Sorry, I'm looking at rules.
10 sub
Statutes.
statute. So 673.010 sub 14, I believe. Yes.
Got it.
Yeah. And so it could just be professional accountancy services relies on the definition of professional as noted in blah, 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 or whatever, however fancy you make that. If we don't do that, we do have a key issue with what we have in this draft. And we didn't say, but not limited to. It actually says, but limited to. So we either need to add the not or refer to the other. If you see what I'm saying there.
Oh, so this one kind of narrows it down a little more.
kind of in the third line, it should say
So that would
including,
go even broader though.
it would.
Yeah.
It would, but then it matches.
Yeah.
But I bring it back to match. And given that it's already in statute, I'd be inclined to say, I don't want to touch it.
Yeah, I just think for clarity purposes, if TAC was concerned that we're introducing a new term, we don't want to create a lot of noise around what we're doing. So if we can simply reference the statute, that should take care of it.
I agree that in this case, I get what you're trying to say, Angie, that this is kind of mirrored over here, but I think we take the argument off the table if we just substitute the citation.
Yeah.
If we can do that and say, we're not creating something new. This is the citation we're using the term professional as defined in ORS blah, blah. Because I think like the members of the committee, I'm worried about being exposed to you're adding new stuff, but we're actually not adding new stuff. And if we can make that clear, then I think that will hopefully help.
I would agree.
Say professional accountancy services for the purpose of this section means professional as defined in ORS 673.010 sub 14. Sounds so weird. 14.
14 is
professional. I'm on the board website.
Sorry.
Well, we'll make sure that it is the right word, professional. But are you looking at the most current version of the statute, which is okay? I went onto your website and clicked on statutes, so that's what I'm looking at.
I'm looking at 15 and I think this is pretty current. Professional means arising out of or related to the specialized knowledge or skills associated with certified public accountants and public accountants.
Angie, I'm looking at 14. I'm on the web too.
I was like, I'm on the website too. and it
You're
says
not crazy.
Yeah.
I
Okay.
just wanted you to know you're not alone.
All right, so even I'm looking at.
So
Usually I'm the one
Yeah.
in crazy territory.
oh, like what years was this? The one you're looking at last changed? Do you see that it says 2025?
Yeah.
So it says it does say 2025? If it does, then you're looking at the right.
No, I'm okay with stipulating on the record that I'm the one that's crazy.
Okay.
That was Martin for the oral record.
So our solution here is
It's something like for the purposes of this section means professional or something like, or for the purposes of this section.
Refer to the definition of
Funny to me the
professional
way
and
it's written, but like something around basically saying like we're going back to whatever that definition is above. I feel like we need to fiddle with that language a little. Sounds a little funny, but it means professional as defined in ORS 673010.
yes.
Yeah, and it's beautiful because it has the whole list in there around
Yes.
attestation, compilation, audit, management advisory. So we're solid.
And then back in ORS further defined by the board by rule, which
Exactly.
Which is in 14.
Yeah.
Yeah.
doesn't say further in 14. It just says or as further defined. It doesn't say or just
Yeah, or is further defined.
does it say further?
Was
It
defined
does.
by the board.
Okay.
So
Yeah.
it's already in 14. I don't think we have
Okay,
to.
it says as further. Okay, great.
Yeah.
'Cause you wanna make sure you have that word further in there. Otherwise, redefine it however you want it to. So
All right, and I just looked it up on the the Oregon.public.law website, and that definition of professional is listed in 15 on that website.
on which
So
website?
if we can make sure we have the right one.
Yes, and that used to be the correct citation, and I don't think that they've updated it yet to the post January 1, 2026 version, which includes the edits that were made by Senate Bill 797.
Okay.
Because there were definitions edits that were made in Senate Bill 797 that took effect on January 1, 2026, and that changed some of the numbering of the definitions in there.
Okay, so the one on the Oregon Board website is everything's dated as 2025.
Yes.
So maybe it's not updated.
No, that is
The
updated.
15 is
Oh.
It
Okay.
should be. I'll double check. Regardless.
Okay.
I will go to the legislature's website and I will pull it off of there.
Thank you.
So our solution here is to make a direct reference to the statute rather than trying to define it here.
Yep.
And
Yes.
I think that,
Mhm.
so I'm going to ask for a motion that what we do is we refer to the statute. Angie can look up the most current definition off the legislative website. So do I have a motion?
Elizabeth Almer, so moved.
Do I have a second?
Amanda Bell, second.
Amanda, second? Is that correct? Yeah.
Correct. Yep.
All right, let's vote. Sherry,
McPherson, aye.
Elizabeth,
Aye.
Amanda,
I
Melissa,
Melissa Wall, I.
Beth,
Beth Spencer, I.
Ray Johnson, aye.
That is all the way through. Mm-hmm. Yeah. Mm-hmm.
Ray, we can't hear you right now.
All right. We're in an hour ahead of time here. We're in time for Melissa to have to step out. We've covered all the comments. And I want to thank the committee for two things. The depth of the discussion was good. I think we brought in a variety of viewpoints. But at the end of the day, I am pleasantly surprised at the consensus
Mm-hmm.
that we have here. I mean, every vote was unanimous. I want to thank you for your work ahead of time because this was not a meeting you could walk into without being prepared, and you were prepared, and I thank you for that because it allowed us to move along quite quickly and with some thorny subjects. So, is there anything else that, Martin, we need for the good of the order?
No, Mr. Chair, you have the option of adjourning the meeting and simply putting the time for that on the record.
Okay. Do we need to be thinking about schedules for another meeting, or do we do that down the road?
We can do that down the road.
Okay. With that, I'm going to have a motion to adjourn the meeting.
Beth Spencer, I motion to adjourn.
Melissa Wall, I second.
Melissa, second. Just this one. All in favor? Aye.
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 Motion
Aye.
passed. Listen, thank you, everybody. I think we got a lot of good work done and very quickly, quite honestly.
Yeah.
Thank you for your time and effort. It's much appreciated.